takes a lot of time and money to build a class. So that's the main drag on privacy class actions. If you're going to bring a class under English procedural rules, you have to be able to prove that the claimants have the same interest and suffer the same loss. The arguments for claimants are potentially stronger for data breach. If a database is compromised and tens of thousands or hundreds of thousands of people have had their names, passwords, credit cards compromised, the only real difference is how thick their skin is. So some people get more concerned than others about data spills and data breach. So there is still some subjectivity, but I don't think that that is an insurmountable challenge for claimant lawyers.
The calculation of damages for mass data breach claims is something that still needs a definitive precedent. It will hopefully come from the Supreme Court in the Morrisons decision. For now, we've seen courts reluctant to award any damages unless there is some evidence of distress on the part of the data subjects who are bringing the claims. Where distress has been found to have occurred, we've seen damage awards from somewhere between the hundreds to the low thousands. The principal key risk area I'm seeing for clients in respect of data breach claims is focusing on what should be said to the regulator as opposed to what should be said to data subjects. Quite often people would be focusing on avoiding a significant fine, which could be up to 4% of global turnover under the GDPR, while placing less emphasis on what they should say to data subjects who have been impacted by the breach. In circumstances where data subjects could make claims for, say, £500 per head, multiplied by, say, 10,000 data subjects who are implicated, that could quite easily result in a financial liability that outstrips any regulatory fine that the Information Commissioner's Office may seek to impose.
There are many things that clients can and should be doing to mitigate the risk of privacy class action. First and foremost is just to be aware that this is an issue and it is a real risk. It's not simply a case of GDPR fines. There is exposure, given that there is no need to prove financial loss, to have to pay out potentially quite large sums in group actions. So what should clients do to prepare? Well, first and foremost, it is to put in place good policy, good state-of-the-art technology, good governance is critical, and train people to ensure that everything that can be done is done to protect personal data, IP, intellectual property assets of a business, and to prevent it from falling into the wrong hands. Prevention is always better than cure. However, we live in a very interconnected world. There's no such thing as full security, so clients should also prepare for the worst, normalise the risk, and carry out tabletop exercises and training in how to investigate and respond to a data breach. In addition, if you are unfortunate enough to be the victim of a data breach, you should think about certain tactics to minimise the compensation claims that might be payable. So, for example, one of the things that we are discussing with clients is to offer, where appropriate, credit and fraud monitoring services. If claimants don't take them up, then there's a fairly good argument that they can't be that distressed.
Other tactics which may be employed in response to mass claims may be the classic divide and conquer when it comes to any large-scale breach claim. Making some offers to certain claimants who've suffered certain levels of distress while making no offers to others will allow the class to quickly be split between those data subjects who've suffered particular distress and those who may have a more higher evidential hurdle to meet before distress can actually be identified and proven to a judge.
I would also encourage all clients and organisations to check insurance policies. Cyber insurance is widely available. However, cyber insurance also varies very significantly in terms of what is covered, so the heads of loss, and also how much is covered. And many clients may think they have cyber insurance, but there's a difference between having cyber insurance and having cyber insurance that will actually be helpful and pay out in the event of a significant cyber hack.
In defending mass data breach claims, clients need to ensure that they have a law firm on board who understands their business long before the incident of the breach. And I say that because having lawyers who know the business, who have been involved in designing the processes and procedures to respond to that breach, will ensure there's been a level of stress testing at a very early stage to allow the most robust possible defence to proceed when it comes to actually responding to any claim that may be brought by a mass claimant law firm.